in this session. I have been, as Lori said, I've been doing this a long time. I've been doing this 18 years. And almost immediately when I started practicing, I also started doing the seminar, and it's evolved over time. I tend to focus on more Legos than I used to, because Lego does a lot of things correctly in the intellectual property space, but they also push the boundaries a little bit. I also, this chat is, it's large. I mean, there's a lot of patent, trademark, and copyright law that I cannot even manage to scratch the surface in an hour and a half. We used to teach this in 3 hours. That was really boring, and I still can scratch the surface. But we're going to try, and I'm going to try and give you the things that you need to know. There's also slides in here that are things that you should, like website information or things you really should know. So those are drawn out for you. And I can also get these slides to Lori later, assuming the technology works with me. I use Prezi, and it has not been functioning the way it used to. And I think that's a Prezi issue across the board in downloading PDF slides. So we're going to talk about patents first. When we look at all of these properties, there are two ways of looking at acquisition of patents, trademarks, and copyrights. There is the business decision to have that business asset. There is also the desire to stop others from doing something that is a competitive advantage to you. This is going to talk a lot more about the asset accumulation piece and less on the infringement piece and how to stop others, mainly because most people, the trajectory of getting the asset is the same across the board. Infringement is very fact specific, and sometimes there's things that come into play that are abnormal, and I can't touch on all of the different distinctions on that, but we will touch on it a little bit, especially in this instance. I mean, all of these property rights are also intended to keep people from doing something. That's why we get them as assets, because if you're seeking funding from a bank, or if you're seeking funding for venture capital, or if you're selling a business, someone wants to know that what you're doing is exclusive to you. So having a patent to wave around, or a trademark, or even a copyright, to a certain extent, shows that person, I have this corner of the world locked up in this way. And that's why we tend to go about doing that. If you're not interested in an asset, or not interested in stopping others, these are really property rights that you want. It's an expense that you may not need, but we're going to talk about certain milestones, because also businesses change over time, and you may not be interested in a patent now, but you may be in 2 or 3 years. So when we look at excluding others from patents, it is making, using, offering for sale, or also importing. We see that more with importation. There's a few property rights in here that are really good with that. Patents are a little bit, there's still a hurdle there. You still have to go to court to stop others from doing them, except if you're on Amazon. Amazon will also help sort of serve as a court in that sense, and stopping others from bringing things in. When we look at patents, there are 3 types of patents. We have plant patents that are represented by this lovely fake Lego plant. Plant patents are actually for real plants that are asexually reproducing plants, or seeds that have been genetically modified in some manner These are rare, that they don't often occur outside of the University of Arkansas, being within the state borders for filings. I've done a few, but again, they're rare. The main ones when we think about patents, we're thinking about design patents, which are represented here, and then also what we call utility patents, which on their own come in different kind of flavors that I'll dig into in a little bit. It's important to remember with deadlines associated with patents, you have, it's a pretty hard and fast rule. Once you publicly display, sell, or discuss your invention with somebody that's not like your spouse, not like your mom, you have 1 year to file for a patent. The patent office will look at your social media and see if you have what we call it a bar to patentability, the public disclosure more than 1 year. If you have anything out there, they'll flag it and they'll use it against you in getting a patent. They'll also require of you to disclose what you know as well. So even if they're not looking at your social media, you have this obligation to tell the patent office, okay, wait, I knew about this thing. It wasn't necessarily me talking about my invention, but I knew something. So one example, a guy was working on intermittent windshield wipers, and he had looked at a lot of other technology. He owned a specific car that had this specific technology. He owned a manual. He made very small changes, didn't disclose the manual for the car that he owned. And the patent office said that he did not meet that burden, and they took away the patent. So it is a pretty important thing to know that you have that bar and those duty of disclosure obligations. So design patents are my personal favorite. I specialize in designs and partial designs. A lot of my practice area is in products that are on the shelf. So that's why I tend to be in the design space. Designs are used for articles of manufacture, and the article itself is very important for the design. If you design a set of hair for something that's not a toy figure, say it's a wig for a dog, it may not necessarily compete with this hairpiece for a toy figure. In the same sense, hair for human is not going to compete with this hairpiece for a toy figure, which is one reason why Lego could get this through so easily. The issue, a lot of inventors want to name their things interesting names. I mean, we do see that a lot more with the utility patents when we call cell phones portable electronic devices. True, they are that, but also with designs, the name is very important. If you call a lip injector pen something other than like a crayon, it's going to get judged against crayons. It's not going to be able to be infringed by other lip injector tools, which is actual case that came up. So this is this hairpiece for an article of manufacture. Partial designs are important for a lot of products that we're very familiar with, like blocks, the lamps, or shoes in particular. We get a lot of shoe designs that are out there that are for, they call them for shoes. Again, names matter, but when you're Nike, apparently everything's a shoe, even if it's just for a cleat, one cleat on the bottom of a shoe, or the tread of a shoe, or just the portions of the laces. Nike likes their partial designs. A lot of other companies do as well. But we see this a lot more in clothing than we do in normal articles. But it's important, if you are in the space that would be looking at designs, to have a design patent attorney that knows what they're doing. We've seen some very recently that were filed for people that were close to our area, that were very narrow designs. Designs are judged by if they look like something that's claimed in the patent. If, for instance, someone else has a block but is missing this flower motif that is on the top of the block, it is not infringing that design. Also, if this design got applied to a different shaped block, because this block is not actually claimed in the patent, it is just for this flower design, then it would be infringing. This is why we see partial designs, and why you need someone that knows what a partial design is, rather than just filing a design patent. Design patents issue very easily. It's rare to see one that gets rejected at all. I'm in this space a lot, and so every now and then I get one rejected. We think the issuance rate for designs is over 90%, based upon what we know about what is filed and what is getting issued. They tend to take about 2 years to the point where, like, from the date of filing to when they get issued. So the patents are not a fast process. None of these processes are fast. But one thing, good thing about designs is if you've got one pending and someone suddenly decide you just need that patent right away, you can pay the patent office to speed that design up while it's pending. You cannot do that with utility patents. One important thing also is to know, like everyone wants to know, when am I patent pending? Once it's filed, you're patent pending. If it's a design, provisional utility, plant patent, it doesn't matter. As soon as you're filed, you're patent pending. Utility patents are what most people consider when they think about patents. They think about it's covering how something functions. With utilities, that is true. It usually is for either an object and specific parts of that object, or useful processes, machines, or compositions of matter, which a lot of times that's a vaccine or medicine, some type. We see those things. People usually ask me about food, and should they get a patent on their food and their recipe for that. We tend to look at food differently, because except in very rare instances, when you put food out in the public, it's sometimes hard to understand completely how it was put together, especially like with Coke. So those recipes, we consider them trade secrets, unless you can see something and take it immediately apart and say, okay, it's got this amount of water, this amount of sugar, and this amount of whatever flavoring, and I can put it together that way. We don't really want to tell the public what the recipe is. We want to keep it secret. Secrets last for forever, as long as they're secret. Patents last 20 years, at least utility patents do, which would be the way of protecting a recipe. So we want to consider those things. But if you've got a recipe and you're thinking, oh, okay, I need to make this a trade secret, you should probably still talk to an attorney on how exactly to go about those trade secret obligations, and like what are the hurdles. In Arkansas, we have tests to say, okay, was this really a secret? And you don't really want to just think, oh, I've got this trade secret, nobody knows what it is, when actually I haven't complied with those secret rules, essentially. When we file utility patents, they are different in a lot of ways from designs. Designs are mostly the drawings. The major expense is almost always the drawings. The drawings tend to be, if not more than, but or at least equal to the filing fee for the design patent. And then the attorney fee actually tends to be a little bit less than both of those together. So with designs, we tend to look at maybe $2,000 for a filing. Utility patents, in contrast, are a thick filing. They are usually lots and lots of pages describing exactly what's going on. You'll notice in the design pictures, there are no numbers related to this. It's just a drawing. In contrast, the utility patents have numbers usually associated with drawings when we're talking about specific pieces. So in this instance, this patent describes a toy building set that has, and again, attorneys like their patent attorneys specifically, like their odd words. So a tubular, elongated, flexible toy building element, which is more than likely number 6 in this drawing. And then we've got these connector pieces of 5 and 7 that are probably called something along the lines of connector pieces with channels interior. And so they are very detailed descriptions and pages of pages talking about each one of these numbered pieces, and also probably more numbers and subsequent drawings. So all of that to say, utility patents cost more. It takes more time to describe all of these pieces, and that cost a lot of startups when they're thinking, or businesses in general are thinking, oh, I've got this new invention. I need to file this because I've got that 1-year potential bar going. So how do I do this and like still decide, is this product worth it to me? And that's, the patent office has recognized that and thinking, okay, well, maybe we don't have a full utility patent. Maybe we have a provisional filing and a non-provisional filing. So the provisional filing is a cheaper manner of filing. Usually, in my case, I tend to still have the lengthy description, but it's missing a few elements that would be in the non-provisional filing, which reduces costs. The filing fee is also cheaper. So usually with a provisional filing, we're looking at $3,000 to $4,000 in contrast to $6,000 to $7,000 for a non-provisional filing. And that helps a business think, okay, this is an initial cost. I can go test the marketplace and see if anyone's actually going to buy this thing. And if so, then I can move forward with the rest of it. And normally the rest of it is not an additional $6,000. It's most of the work's already been done. We just have to add the other elements in there and pay a higher filing fee. So it does tend to be something that a lot of people are interested in. Provisionals aren't examined. They only last really for a year. A lot of inventors wait closer to that year period to see how successful is this going to be. Some of them too, also after 2 months, come back and say, okay, I filed. This thing's going gangbusters. I want to file for the non-provisional now. So you're not required to wait the full year, but you do need to file within that year. So, take a drink real quick. My allergies are insane. As Lori knows, I run a lot. And so I run outside. This is a constant problem for me. Okay, so with patents, all patents are examined, except for those for what is being proposed as a patent, since it's being given the ability to stop other people from doing something. The goal is to make sure it's something that's new and also something that we call not obvious, which is the worst term to explain to people, because in some instances where it's like, okay, I get it. It's not changing out something simple that would be an obvious change. But the patent office sometimes takes that obvious change to a very large difference. You can't change out a screw for a bolt and say, okay, I get a patent now. That's not how that works. That would be an obvious change. It's one that we can all recognize. But the patent office will also look at other things. So like for one example, one thing that I worked on a long time ago, because Reynolds Stadium's been out there for a while with the new windows that open up for the skyboxes. The patent office looked at those windows that move along on a track to open and compared those windows for a building to a window in a very old pickup truck. If you ever, my grandfather had this kind of pickup truck, where the window in the back behind the driver and the passenger would slide back and forth. Patent office thought those were the same thing. Now, windows for building and windows for pickup truck and the tracks needed for these things are drastically different. And so we have to explain sometimes to the patent office what you think is obvious, a window and a window is not actually obvious. People had to make changes, and those structural changes tend to be what we are explaining to the patent office over and over again why this is important. So when you're working with the patent attorney for a utility application, a non-provisional utility that's going to get examined, it is very important for you to think through the process of, why did I make that change? Why is my way better? Because that should be in the patent application, because you're going to have to explain it to the patent examiner on why you should get a patent and why your version is so much better than the way it's been done before. One substantial change between the provisional application and the non-provisional application tend to be claims. Provisionals do not need to have claims because they're not examined. Non-provisionals, since what is examined is actually the claim set, are the things that they need this claim set. And claims are one of those weird little things that you need to read very closely. It is insane to me how many inventors actually review more often the background section and less the claims. I always have to tell people, go back and read the claims. This is a section that is the most important. So when we look at a patent, if you've ever, they're out there, Google has a patent section for you to go look at if you want to go and kind of examine to see what else is out there. And I recommend that everybody do that if you're inventing things. But when you're looking at the patent, there's the drawings, there's a description, which I talked about earlier, that talks about all the different pieces. And at the very end are the claims. And it usually says something along what we claim or I claim. And there's always at least one claim. Sometimes there's more. Every filing gets 3 independent claims, and this is an independent claim, or less. And then you can buy additional independents if you wish, and 17 dependents. So a dependent claim would be like this claim, a method, and then it would say the method of claim 1, including also taking the data structure and adding something else to it. What is infringed are the claims, and what is examined is the claims. So when we look at those, it's one long run-on sentence. very rarely do attorneys think about how much grammar they're going to use in their life. Luckily, I had grammar classes in college to prepare for this, but it is this one run-on sentence with all of these clauses that relate to each other and making sure they relate to each other appropriately. It can sometimes be a trick. That's one reason why non-provisionals are so much more expensive. But these things, if you've got too many claim elements, it may get through examination easily, but it may also make it harder to infringe. If someone is doing, we would call these A, B, C, and D. If someone's doing A, D, and C, A, C, and D, but not B, they're not infringing this patent. On the other side of things, if you what your big, huge thing to get through this patent through is B, you have to do this because everybody else was doing everything but B before. You're going to have to include B to get it through examination. And just knowing those trade-offs, sometimes it's a negotiation during the examination process. We may have a claim set that has parts of B in it, and a dependent claim that has other parts of B, or just various little add-ons like that, trying to make it go through. And then maybe we don't like to think of it as arguing with the patent examiner, because we want them to accept it and move forward with the patent. So a lot of it is negotiation and saying, okay, I'll add this in and you'll allow my patent, and then it will move down through the process. Like I said, with designs, they tend to take time, 2 years. Utility patents, sometimes they sail through. I had one that issued earlier this year that it had been pending less than 6 months. So sometimes they just fly through. Other times, there was one that I filed the exact same time as that one, and it was in a different area. It was a medical device versus a baseball training device. That one, that the medical device got examined many months later, actually. I think it was 8 months later, and it just, yeah. They don't always move as quickly. They don't move. It depends on what we're doing. Computer readable things, I have had one that has been pending 4 years, and that is normal. So with the filing dates, I mentioned those being important. The priority is given to people that file first. So when you're disclosing for a pitch competition or for any reason, like business to sell the thing, having that patent pending can sometimes be important, because if somebody sees it and thinks that's great, they may not think, okay, I want to file that exact invention to the patent office. Most people are not diabolical. Most people are nice and normal humans. But other people may think, oh, that's great. That invention on that block is really cool, but kids aren't going to work their hands like that very well. So maybe if I change it in these ways, and then they file on that filing, if you hadn't filed before and your block was the first block, the second block might work to block your block going through. So these are important considerations if you're pitching or discussing things. We like to tell people to get confidentiality agreements, and I mean, that's an expense. It's a much smaller expense than filing for a patent. There's also other reasons for doing that. Let me get a drink again. They may have some components of the invention that they're really good at. They know how to sew, they know how to draw a CAD, they can do these things, but they may not be able to manufacture at a level that's necessary for that invention to get through for public consumption. And so when we're going through that process of manufacturing, those things change to make it more economical to file or to produce, or also just to make it more feasible. So those consultants that you work with, or someone like an engineer or a designer, they may have feedback for inventors on, you should change this, you should use this material, you need to make this adaptation to the invention. Those are considered inventive steps. And then that makes that consultant a potential inventor. We don't like that. I mean, it's fine to have additional inventors, but then that means they can do the invention. Every inventor has the right to practice the invention. You have to tell the patent office, all the inventors, so that consultant may end up with a property right in your invention. The way we stop this from happening is by having that consultant early on sign a non-disclosure confidentiality agreement that has invention assignment provisions. So if they do create something while they're helping you with the process, they have agreed ahead of time to assign that to you or your business before you move. So that way you can include them on the patent like you're supposed to, and they'll sign that assignment when it's time, and you have all the patent rights. So this is a very important thing as you're moving through that invention process to keep in mind. And not all non-disclosure agreements are the same. Ones that you get off the internet aren't always ones that include this. So while it is unfortunate to talk to an attorney, I know most people hate us, it's one of those things you should probably still talk to an attorney and say, I need this in my non-disclosure agreement. So like I said, there are things that you need to have. There's slides in here that are important. You have to have certain things for a patent. You have to have drawings. You have to have a written description. You have to have a filing fee. And you need to file within at least a year of public disclosure. Faster is better. And here are the websites for the patent office at the top. And then Google patent search is patents.google.com. Again, it's user friendly. The patent office has its new patent public search. I haven't added this yet. It is getting better. It's starting to function a little bit better. It's not as user friendly still as Google, where you can type in a word and Google will give you like similar keywords. But the patent office is trying. So eventually, maybe as you go through the process of searching Google, you might move to the patent office search tool as well. So, Lori, I think there's a question. I do see that, but I don't know what it is.
That is not a question. And okay. These were some other comments from earlier. So we do not have any questions at this point, unless anybody wants to jump in with some questions. We'll just wait. They may have been waiting for you to finish. Now is the time for patent questions.
It's okay, I can drink a tea.
Yeah. Do you work with micro businesses or only large businesses?
Almost all my clients are micro businesses.
Okay.
I work with a lot of women. There are not many women patent attorneys in the state. I have an associate down in Little Rock that's a woman, and yeah, there's just not many of us. And then there's a friend of mine that's down in Little Rock as well. So almost all of them are micro businesses or medium, small to medium size.
Anything else?
If you're interested in designs, I tweet about them a lot. But okay, we'll move on to trademarks. This is usually the part that most people are more interested in. Mainly because it affects almost every business. So trademarks are also my favorite. They interact a lot with design work. We see designs, as you can see, this looks a lot like a design patent, but it's a trademark. And trademarks can function in odd ways. They are different in so many ways from the patent area and the copyright area. Patents and copyrights are things you actually create. They are something that you're working on, toiling away in your garage on, something like that, that actually should be rewarded as a property right. Trademarks are instead what we create in the minds of other people. I know Lori loves trademarks as much as I do with her marketing background, but so trademarks, we can file them and get them registered, but the real work is that advertising aspect and trying to get people to recognize, wait a minute, that is associated with Lego, that is associated with Meredith Lowry. But they can be just about anything: word, name, symbol, product configuration. I've done quite a few of those that are distinguishing your product or your business from everybody else. They last pretty much forever, as long as you're using them appropriately and not allowing anybody else to use them as well. It's really hard for them to die. And the trademark office, I've got some on my docket, they're older than me, and they're going to keep going because the business keeps using. You don't have deadlines associated with trademarks like you do with patents. There are reasons to file early with trademarks that we're going to get into, but you can file them pretty much at any point in time with the business. You can also file them with the intent to use them. The examination process right now, the trademark office is currently examining trademarks that were filed last August. So that is a substantial change since our numbers that were for examination in 2019. A lot of this is because a lot of businesses formed during 2020 and filed for trademarks because of why, y'all get into all the reasons of why you should file a trademark, but they were trying to counteract some of the bad behavior and protect their businesses. Those intent to use trademarks, we see a lot of businesses, especially ones that are on the medium size, that are working on product launches, they're filing earlier to allow the examination to occur before the product launches. And that way, at least from a liability standpoint, you can say, but the trademark office did not see a potential for this being an infringing mark because that's part of the examination. So I had a good reason to actually move forward in using it. Trademark liability, like the patent liability, is based upon you actually doing something that would hurt a existing property right. So with patents, if somebody has a patent, you would infringe it if you did what their patent claimed. If you are using somebody else's trademark for something that would confuse the public, like using a Lego man for a Lego or block toy, then that would be confusing. If you, Lego's bad because fame also comes into the picture with trademarks. But if you were also using, say, this lovely little dog, like my lighting's bad in here. If you use a dog figure for big trucks, that would be infringing of a certain truck manufacturer that uses a dog, bulldog for their trademark and branding. But if you use it for, say, a restaurant, maybe not, because there may not be any other restaurants out there, and that's not going to create confusion. Someone's not going to think your restaurant is associated with the truck manufacturer. And so when we look at filing early for product launches, we want that examination to happen at the trademark office. I have one client right now, we went through the examination process right as the trademark office was saying, hey, you get a trademark, it's great. Somebody else came to him and said, you're infringing me, I've got a registration. But the trademark office doesn't think that. I don't think a court will think that either. And it makes that process more of a negotiation and less of a, I don't know what's going to happen here, because we at least know someone agrees that it's not infringing. So, let's see. With trademarks, I also teach this class to students, business students, a lot. And we talk a lot about product or market analysis, and I'm sure Lori's talked to you all about this too. But knowing your customer is important. With trademarks, that comes into play a lot more. It's important for you to understand what your customer sees you as. So like clearly Lego has done that. It's also important for you to think through, like, what do you want your business to have? What do you want to be known for? Or what do you want to stop other people from doing? So in Lego's case, one reason why I love them is that this Lego figurine is old, is out of patent. It once upon a time was also a utility patent, as you can see with all the numbering. It's been since used in marketing in such a way, pushing those figurines into the consciousness of everybody in the world to recognize them as Lego's trademark. So having that understanding, your trademark counsel should know these things and know how to kind of like coach you through moving maybe your patent work, things like that, into trademarks as patents start to expire. It does not always work. This toy brick is, unfortunately, it's also on my wall. You can tell how much I love Legos. Graduation present from Los. But these are things that Lego has tried. It has been unsuccessful. It's going to keep trying, clearly, to get this through, but there's some things that are just never going to work as getting through as a trademark. It's too functional. And that is, the trademark world will not go purely into the functional space. So we talked about confusion aspect for examination, the trademark office looking at that piece and trying to say, okay, wait a minute, is this something that's like others that are out there? And typically that's only judged against other registrants or prior filed trademark applications. The trademark office looks also to make sure that the mark itself functions as a trademark. So is it functional? Are we trying to file for something that everybody in the world should have a right to get to use because of that functionality piece. You cannot get certain things through, like it's hard to think of something right now, but other, like the end of a socket for a plug-in, you can't protect that, but you could protect the socket being blue. Or the specific shape of the Apple plug-in, that square shape versus all the other shapes for electrical plug-in. We also look at, is it something that's generic? Pretzel crisps are generic. They are not something that can be protected despite all the attempts that the owner of Pretzel Crisp has tried to do. We see other trademarks in a kind of spectrum. So there are the descriptive words, and then there are the kind of suggestive of Netflix. And then we have the arbitrary and just kind of fanciful trademarks of Lego and Google that didn't really relate at all to what they were doing before they started using them. Google runs the risk of being too well used as a term that I'll get to in just a minute, but like most people are falling in the spectrum of almost descriptive or suggestive. I understand why people want to use a descriptive trademark like Spot Not for car washes. But on the other side of things too, it's harder to get the descriptive words through. Generic's impossible. The trademark office is going to refuse it. But the descriptive terms, sometimes the trademark office says, yeah, that's really pushing it. Other people should get to describe their products in such a way. So when we start looking at descriptive trademarks, we look at logos as well. And the more fanciful and kind of graphically designed of a logo, we can get those things through like Spot Not. That's important to consider. Sometimes the trademarks, like nowadays, Spot Not probably would not go through for that kind of logo because it's just not enough. We see a lot of trademarks being filed, and so the more that are out there that are trying to use similar things, the more the trademark office is going to say, you've got to give me more to this trademark to get it through. Like I was suggesting with the dog, we see trademarks also used, but lots of different for different uses. So we can have Apple for Apple Music. We can also have Disney using an Apple for Descendants from their movies. And you see apples for underwear. The trademark office is not going to see these as different, or is not going to see, sorry, got choked up. Are not going to see these as competing or people being able to create confusion in the marketplace. So they're all allowable. Some marks are going to cross different areas. Clothing, despite me using pains in this sense, or Fruit of the Loom, sorry. Clothing tends to cross a lot of different areas. And the trademark office in particular now will see clothing as like branching out into maybe restaurants or beauty items and things like that, mainly because we see a lot of clothing getting filed. That section of the world for trademarks is very densely populated. A lot of this is because of Amazon and brand registry, because if you have a trademark pending with the trademark office, you can get onto Amazon's brand registry, and that gives you some benefits in getting to control what if other people are using your trademark and poultry. The trademark office puts clothing in a completely different class than others. Some classes make sense to look crossover, restaurants, food. Those the clothing crossing over into restaurants, while some restaurants sell clothes, it's kind of a weird thing. We're seeing the trademark office do that. In this instance, most people that would file a trademark on their own or have an attorney that just files trademarks every so often, these are things that someone wouldn't know. I would recommend heavily that you have a trademark attorney that files frequently with the trademark office, because these oddities that the trademark office does are not easily seen unless you're filing at a large scale. With the trademark office and the patent office, both will tell you you need counsel. You can file both on your own, but they are going to highly recommend that you have someone. I see the stuff that gets filed by people on their own. I would also say you need to talk to somebody. Just because it makes your life easier. And I've also talked to a lot of people that have missed deadlines because they're not watching it. They're running a business. So, like I mentioned with Google, Google's running a risk of getting known for almost substituting itself for what it's doing. That's the same thing as like with Xerox. Xerox and Nintendo both did ad campaigns to counteract the ability to create their trademarks as generic. We call it genericide. The students love it when I use this term. But that it's essentially the public taking a term and using it so frequently. You would think it's a good thing because your name's out there, but they're almost using it interchangeably for other products. So all copies are not a Xerox, but only Xerox copiers can create Xerox copies. And so it's one of those things. It needs to be functioning as a proper noun. And then if you start seeing your trademark get interchanged for the product itself, that's a risk. And you need to work to stop that. You also need to work to stop other people from just using your trademark in general, because that's a problem. Other problems, and one reason why we say file early, this is the most common issue, is that somebody else may start using a similar trademark to you and file either before you or create trademark rights in an area that would then keep you from coming into it. So like Whataburger, the Texas chain, cannot have a Whataburger in Russellville, Arkansas, because of the pre-existing Whataburger that is there. On the same sense, the Whataburger in Russellville cannot move itself to Fayetteville, Arkansas to have a burger chain, because Whataburger in Texas filed for the federal trademark registration. And so the only place the Russellville Whataburger can function as a Whataburger is in Russellville. All other trademark rights, because of that federal filing by Texas Whataburger, then got given to them because of the filing, even if they weren't there. That's what the federal registration does. It sort of descends into all the places where you could be to allow you that ability to branch out into those areas. Otherwise, you're on a county by county basis. And these are the cases that come up that are the most problematic for a person using a business, or even just an attorney. I've spent many times of just going through and trying to figure out who used what where first. And with social media, you think, okay, I used it, it's out there. That's not how that works. Just because the world doesn't mean that anyone saw it. in those areas. So the way we show use is based on sales. And that's looking essentially of, I sold this in Benton County. I sold this in Sebastian County. And who sold it first then? That's a lot of paperwork. On a county by county basis across the world or the US, that's reams of paper. And someone that's billing you on an hourly basis is looking at that. So all of this racks up quickly. The times I've seen massive cases on this have been really messy. Other times we can sort of negotiate it out and carve up the world. I've got a few of those carve up the world cases right now. I can say that ultimately no one is happy with them. I mean, someone's going to get locked out of a certain place because of what's somebody else has done. And it could have all been solved earlier if someone filed earlier. We also, during the pandemic, saw a lot of problems with domain name, not really squatting, but fraud. So like, in instance, we'll just keep using Whataburger. If you had Whataburger.com with just one T and somebody else used Whataburger, maybe replacing and adding two T's or taking one of those A's out and putting an @ symbol in, it's really hard to tell that. When you're getting a bill or an invoice from that email, it may look like it's coming from a legit source, and it's really not. But if your customer is paying it because you're going to the website and it looks like your website, it looks perfectly normal, then how are they to know? And a lot of times with clients that I've dealt with this, they feel bad for their customer. So they're sort of helping them with it. On the other side, the business has to take care of the infringement or the fraudulent occurrence going on. And a federal registration makes it a lot easier to get somebody a domain that is fraudulent back into your hands, so then you can take it down and stop that fraud from occurring. This happens oddly way too much. I hear about it at least once every 3 months. So it is occurring. It's not like a boogeyman situation. So yeah, federal registration also gives you a lot of other benefits. It is evidence that you own it. When it comes to selling a business, that's important. It's an easy thing to trade in a business and assign to somebody else. It also allows you to sue in federal court. State trademark rights exist. You can file in Arkansas for those. It only extends to the boundaries of the state. So sometimes we have that because if you're federally regulated to only be in a certain area, like banks or title companies, that's great. Other times we really do see that federal registration more. There is a cost difference. Most people, for a federal registration, we're looking at $1,500, all done and told throughout the process. But a state registration is really one that you can do pretty easily on your own. And the filing fee, I think, is $65. It's just, you have to wait on the Secretary of State to do their work and hope that you've got somebody at the Secretary of State that you're working with that knows what they're doing, because that is a question on its own. They know what they're doing. But the federal examiners usually do know very well what they're doing. They've been doing it a long time. There's not a lot of turnover at the federal trademark level. Those attorneys are usually my level of experience because it's a good gig. You can also use Circle R, which most people want to use if you're not federally registered. I recommend that you use the TM, the top right or lower right side of a trademark. The other huge benefit, especially if you got products coming into the country and you're marking them across and overseas, you can file additional filing with the customs after you've got your registration, and they will almost always, it goes through within days, and you can stop importation coming into the country that's using your trademark. That's outside of the court. You don't have to go to a court and say, okay, I need you to say this person's infringing me. It's a fast process. Customs is really fun to work with on this. They like doing this work, and they will usually be pretty proactive on your behalf. So things for you to know, with the trademark office, it's the same place as the patent office. They're put together. The search function of the USPTO is great to use. That's the TM search thing. They will have all the pending and registered trademarks that are out there, and also the ones that have been abandoned. So you can see if there's other marks that are out there like yours. A lot of times with like clothing, we don't see one word trademarks anymore. We see multiple words. And so knowing, okay, I want to do fit for clothing, then you can see all the other hundreds of fits that are out there and see how they've been modified to maybe get through the process, like Tango Fit or Google Fit, things like that. I mean, we see words get tacked on all the time. The other important area, the patent or the trademark office, is the ID manual. The trademark office, as they cut up the world and look at different things. I mean, some things make sense, restaurant services, but other things, when we look at holiday decorations, all other holiday decorations other than Christmas are in one class, but Christmas decorations are in a different class. And it also excludes candy and lights, because those go in different classes as well. So knowing that you've got to make those exclusions and specific ways of writing out the description are important, because you get a lower filing. The filing fee per class is $250. If you're crossing over classes and you've got, say, you're selling, I'm trying to think, holiday decorations, we'll keep with that. If you're selling Easter decorations and you're selling Christmas decorations, then you've got two classes. That's now $500 for that file. So it's useful to have that kind of frame of reference. The ID manual is constantly being updated. If you're not in there for some reason, whatever you're doing is not included, the trademark office usually can add it if they deem fit to add it within about 2 weeks. I've only been told no once, and it was only because they wanted it a different way. But yeah, you've got, for every trademark, you need that description of goods and services. You have to have the filing fee. And if you're filing something like a yellow head for a Lego man, you're going to need a drawing as well. Okay, trademark questions.
Okay, we do have a few.
Okay.
Okay. I think you said can file with intent to use. How long before use is required, or when is the best time to file?
It really depends on your timeline. So knowing that it's going to take 10 months to examine any trademark, usually. I mean, I did have one I filed in March that's been examined already. That's really rare. If you're going to use it in 2 years, I mean, you go ahead and file an intent to use, but knowing that you're gonna get through that examination process, and then you're going, once it's examined, it goes through a few other steps, and then we have to show use. You get a 6-month window to show use. So if it's gonna be, you're gonna use it in June of 2025, and it's gonna get examined 10 months from now, then you're probably gonna have to pay for one extension to show use. You get 5 extensions, and every time you're paying for them. So you could wait a few more months and not have to buy extensions, or you go ahead and file and just know I'm gonna have an added cost. The extension isn't much, it's $125. Showing use later is also an additional filing, but it's $100 to show, or I may have this flip-flopped. But it's not a lot to add, but it is something that's an added expense for all businesses. So it's just something to keep in mind, and to talk to your attorney and say, this is my time frame. And usually we can work through, okay, when's the best time to file this? There's been a few of mine, they never used it in the 5 months of extensions. And we ended up having to file another trademark the day as it was about to die. I hate doing that. It seems so wasteful.
Okay, one more. If there is a phrase you want to trademark and also want sole rights to put this phrase on an existing set of products, do you need both a trademark and some sort of patent?
So I won't say that it's not done to do phrases as patents. We'll see them every now and then as design patents. It is really, really rare, mainly because it's just not cost effective. It gives you the same sort of liability, like you don't have to know that someone has a patent or a trademark out there to infringe. It hurts you if you knew about it and you did it a lot more than it should. But it is one of those things that with trademarks, it's more cost effective to do that than a patent. You can get slogans through. Again, it's how it's used for marketing purposes. So if the slogan is buried in the middle of text, like if I will try to can file before use, that's not going to be a trademark. That's in text. That's descriptive. It's not trademark. But if I wanted to try and file like trademarks, that's a big old banner thing here. And so it all depends on how you're using it. It's possible though. I would go more with the trademark than I would with the patent.
Okay, regarding domain. So if I own .com, but not a trademark, and if someone creates a fraudulent version of my domain name, do I need a trademark to have legal recourse? Like I own the domain, I don't have a trademark. And somebody goes and uses my domain, do I need the trademark to have legal recourse?
If it's a fraudulent domain, you can go to and get it transferred if it fits all the qualifications of being easy to show that's fraudulent. Without the registration, it's just painful. It's way more work and it takes a little bit longer. So your cost is going to go up in doing that than it would be if you just had the registration. Now, if it's not fraudulent, like it's just another business that gets to coexist and do its thing, sell Lego or sell blocks and you're just wanting to stop it because it's confusingly similar to your Lego domain, then that's a problem. And that is trademark infringement. And it's again, it's so much easier to get it stopped if you have the registration. The court in that instance, it's hands down cheaper to have the registration ahead to stop that.
Okay. Do you work with business owners who invent something, obtain a patent, but then only want to license the idea to an existing company to structure the deal to get paid for the idea for life?
Yeah, that's a lot of people.
Yes, I feel like that's not uncommon either. Okay, any other questions on trademarks? Had a lot of good questions.
How much more time do I have?
14
We don't-
minutes. I've got one more question. What if I create a unique phrase that if I put on an existing product will greatly increase the sales of that particular product? How do I make sure that no one else can do the same thing or is not possible? Or is this not possible?
It depends on the product. I mean, there are some products, like if you wanted to like put Lego World on a Lego, no. I mean, or some things on their own have too many rights on the product. So, but then other things, that's not how that works. I mean, if you bought a bunch of pens that were unmarked and they were, you couldn't tell who made those pens, and then you put branding on them that was unique to you, then yeah, that could be protected. So again, a lot of this, it all depends. Okay, so trademarks, I love. Copyrights, I hate. We're going to go into them, but copyrights, trademarks, Disney is also king at this. They've been moving Steamboat Willie into the trademark world. It is considered, it is registered as one of those moving trademarks. Those are also very rare, but in this instance, Steamboat Willie, while trademarks don't die, copyrights do. This will go into the public domain in January, on January 1 of next year. So a lot of trademark attorneys are just waiting to watch to see what will happen. There may be lots of popcorn for me on January 1. Just watching. I love public domain day. Copyrights, like I said, I hate. They are different from the other property in a lot of ways. Patents and trademarks are classified together. They have more money at the patent and trademark office. The copyright office has very little money. The filing fee, the cheapest filing fee for a provisional application, we're looking at maybe $75 for students to file a provisional application. That is the cheap, like the top filing fee for a copyright. So they're not getting any money in. A lot of this also means that they are regressive in their technology. And so I don't have a lot of pretty pictures. When you go and look at the Copyright Office website and you want to see what does Lego have? What do my competitors have registered as copyrights? You can search for the owner, but you're not going to see what it was. You're going to see the detailed information from the form, but not the deposit material that was sent in. So this is for a construction set horse. I can't see the horse. I can just see when it was filed and sort of get that sense of how long this will last. One other major difference with copyrights versus patents and trademarks, like I mentioned, patents and trademarks, you don't have to know about that property right to infringe it. some clients that have a lot of very unique designs for characters. And if those are trademark properties. So when we look at those, if somebody does a similar character, even that they didn't know about that my client was out there, that's potentially trademark infringement. If they were instead filed, because they are designs filed as copyright and they didn't know about my client, the copyright doesn't function the same way. You have to copy someone for it to be infringement. You had to know. So a copyright owner has this additional burden when they have that filing to show that the infringer had access and actually copied it. This is a huge burden for a lot of people. Sometimes when we look at, like, when people, the most often that I see with copyrights is someone lifting a photo from Google thinking that they can do it because it's on the internet, public domain. That's not a thing. But having that photo and they're dead on identical. So that's an easy argument of, you infringed me, you took it, I have this registration. But a lot of times too, with companies, it's not identical. And that's a hardship. I mean, I see a lot of people that do consulting services. They'll have training seminars like this. They'll have materials, things like this. And anybody can go and do a seminar that talks about copyrights and has similar data out there. They're not infringing me. They're not going to necessarily lift my exact slides out there. They're just going to put the information. And that's a disconnect for a lot of businesses. They want to protect what they're actually doing and that content that they're putting out there, but it's really hard. I will say there are some benefits to copyrights. I mean, it does, having that filing, it's cheap. I mean, it's easily to file. You can file online. The filing fee is around $65. The Copyright Office is really nice to work with. Unlike the other offices, they're very rarely going to tell you you need someone to help you fill out the form. It is a form. And a lot of times too, if you fill it out incorrectly, they'll call you and say, hi, or send you an email. And granted that it's a short window of time to respond to their email, but they'll send you an email and say, I think you filled this out incorrectly. We want to change this to this. And you say, okay. And then the copyright shows up a few days later. They're so nice about working with people. And it's all about filling out that form. They're not actually going to look at what you're doing other than to make sure there's enough there for it to be protectable as a copyright. So this is when copyrights then blur back into design patents. A lot of people, like businesses that have forms, want to protect those forms. I think that somehow or another someone's going to infringe them, and sometimes it does happen. If you have a medical office, we saw one yesterday, dermatology clinic filed a design patent and it issued on their form with their patient intake and diagnosis form. If you've got a large office, then you think that some of your employees are going to go and take everything that you've done and take it to their new office and compete with you. That's when we see that happen. Design patents will protect the forms. The Copyright Office will say, heck no. So you have to have a certain amount of creativity for a copyright to go through. Designs, they don't care. Copyrights last for near close to forever, which does make it harder for infringement purposes. But they're gonna last until we're all old and gray. And I mean, Steamboat Willie from a long time ago, 30s, I think, but also the copyright term is different now. Steamboat Willie, if it had been created now, would probably last whatever, 120 years probably. One other huge benefit for copyrights is the ability to take things down off the social media platforms. So this doesn't work so well with Twitter, because Twitter is frankly a horrible cesspool right now. Though I still post my design patents on there. When it comes to every other social media site, YouTube, Facebook, they will work with copyright holders to remove content that is infringing. Since we sell a lot using social media, this is great for products. But again, copyright tends to happen in weird, freaky kind of ways. I've seen a lot of my clients' advertising materials used more so than the products themselves. And the advertising materials are being used to then sell other products that, so like a picture of geese flying, and they're getting put in a room up on a wall, like a fake room next to a chair, and they're trying to sell the chair. It's just weird. But that's still infringing. And so we can yank it down because sometimes that matters to people. Content of time, I will skip over. Lego is also sued. This is only in here because of Lego. But it is kind of cute. In this parody case, we'll continue on. But beyond just knowing that copyright suits do happen, the main things that you need to know for copyright is do not Google Copyright Office and go to the link. It's not like it's really a cesspool like Twitter. You're not going to see anything wrong there. It's just sometimes a scam site. So the copyright website is echocopyright.gov. Go there. That is where to file things. The other site is the compendium. It is a long list of rules. It's searchable. It's way more easy to read this than the trademark and patent manuals of examination. The compendium, you can search it if you're filing like jewelry or a book. You can go in there and say, okay, text materials or sculptures, which is what jewelry would get put in. And it will tell you all the things you need to know on how to fill out the form. So you should file copyrights before you get it out into the public too far, because infringement occurs at some point. It is easier to stop people if you've gotten the registration ahead of time. I've had clients before that have been head-to-head competitors, but one didn't file the copyright early enough for them before the infringement. And so we were all arguing over the royalty rate rather than statutory damages. Statutory damages are a lot, and you get attorney's fees too if you filed earlier. So it makes it just easier to stop people. Yeah. Oh, and then there's a copyright small claims court. Questions? Oh, you're on mute.
We don't have any questions. I am going to type some information in here. We do offer a variety of services here at the ASB TDC. We offer one-on-one consulting, other seminars, and stuff like that. And our consulting services help people start businesses. We have market research. We can help you with your financials and a variety of other things. And so I'm going to put our website in here, sbtdc.uark.edu, as well as I don't know why that is not clicking through. Oh, I see. and my email address if you want to contact me about consulting. You can also just click on a link to request a consultation to meet with any one of us on our website. So Meredith, we really appreciate you. And we will get back to you with this recording and this presentation. So thank you all for attending, and thank you, Meredith, for doing this for us.
Thank you. Have a good
All
day.
right. Thank you.
Bye.